My name is Jessie. I'm the manager of Member Library Services here at Northern Lights, and this afternoon we are going to be going through a webinar on the topic of FOIP, Freedom of Information and Protection of Privacy for Libraries. So in this webinar, we're going to be discussing the Act and the regulations, particularly in relation to the work of libraries. There are two main sections. There's access to information, and then there's the protection of privacy. And we're going to go through some specific examples in some greater detail about the various facets of access and protection. So we will get started right now. Okay, so the two components to FOIP, the Act and the regulations, so similar to how libraries have an Act and regulations, begin with the Act. So the Freedom of Information and Protection of Privacy Act in Alberta is a law that does two main things. It governs access to information, which allow people to request and get access to records held by public bodies. This helps to ensure transparency and accountability in how these bodies operate. And then the protection of privacy protects personal information from being misused by government bodies. So it sets rules on how personal information can be collected, used, and shared, and this ensures an individual's privacy is respected. In the simplest terms, the FOIP Act helps people to find out what the government is doing, and it makes sure that their personal information is kept private and safe. Overall, it balances the public's right to know with the individual's right to privacy, and it ensures transparency and accountability from the public sector, of which we are a part. The FOIP regulations aim to ensure that public bodies in Alberta operate transparently while protecting individual privacy rights. They're detailed rules that help to enforce the FOIP Act, and in simple terms, the FOIP regulations provide the detailed steps and rules that public bodies must follow to ensure that they comply with the FOIP Act, thus protecting people's access to information and their privacy. So those regulations cover handling requests, protecting privacy, managing records, complaints and reviews, and also training and compliance. So we will start things off with section 1, access to information. So this is the right to access. FOIP grants individuals the right to access records held by public bodies, subject to specific exceptions. This includes records containing personal information about the individual making the request. In this context, public bodies refers to government bodies like departments, schools, hospitals, or libraries. And then the term personal information refers to recorded information that is identifiable about an individual, such as their name, their birth date, their address, their phone number, their email, their age, their gender, their marital status, their financial information, their health information, and their educational history. All of that falls under the category of personal information. Okay, so the applications and exclusions to what can be requested in a request include, so it applies to notes, images, AV recordings, x-rays, books, documents, maps, drawings, photos, letters, vouchers and papers, really any other information that's written, recorded, or photographed and stored in any manner. But there are also exclusions. So some records might be exempt from disclosure to protect privacy, security, or other public interests. Common exceptions would include personal information about others, confidential business information, and records related to law enforcement or legal proceedings. So that might look like software or any mechanism that produces records. That could be records available outside of the Act, like registry, court records, judge records, personal notes, draft decisions. Could be teaching materials of post-secondary educational bodies, research information, exam questions, Published works by libraries, personal or constituency records of local officials, personal records, appointed or elected officials of local public bodies. So all of that you would probably not be able to get your hands on, and you also would not share. And then health information, there's a Health Information Act, the HIA, that applies to information held by healthcare bodies like the regional health authorities. So that is for the most part separate from anything that we would be requesting or sharing. So a practical example of the information that we're talking about is here. A patron named Maria wants to understand the decision-making process behind a new policy implemented at her local public library, which restricts certain borrowing privileges. She submits a formal request to access the records related to the policy's development, including meeting minutes, emails, and reports. So in processing the request, the library would identify the relevant records, including internal meeting notes, staff emails, which discuss the policy, and reports on borrowing statistics. But then they would apply exclusions. So the library would redact sections of the meeting minutes and emails that reveal any personal information about patrons. And then they would also redact portions of reports which might contain sensitive third-party business information. And so then they would go from there. So that's how applications and exclusions would be applied. A patron might request, or a member of the public might request, a bunch of information that doesn't necessarily mean that they are entitled to it. And then there is a whole element of being able to, object to the decisions made by the library or the public body in applying or excluding information that we will get to a little bit later on. So the next thing that we're going to talk about is custody versus control. So custody means that a public body physically holds a record. So the implication there is that the public body is responsible for managing the record, including its storage, protection, and maintenance. So an example of that would be the library has custody of books, library cards, and membership information stored on its premises or in its databases. And then there's control. Control refers to the authority or right of the public body to manage, use, or dispose of a record, even if the record is not in the public body's physical possession. So the implication there is that the public body can access and use the record and is responsible for ensuring it complies with the FOIP Act, even if the record is held by a third party. So for example, a public library contracts an external company to manage its integrated library system, its ILS. The records in the ILS are under the library's control because the library can access, modify, and dispose of those records, even though they are physically maintained by the third-party company. So the third-party company has custody, but the library has control. I hope that makes sense. So key differences. Custody relates to physical possession. Control relates to the authority and responsibility for the record, regardless of the physical location. So the practical implications of this under FOIP would be that when an individual requests access to their information, the public body must provide access to records that it has in both custody and control. The public body must ensure that personal information is protected and handled according to FOIP regulations, whether the information is in its custody or control. And even if a record is outsourced or held by a third party, the public body retains responsibility for compliance with FOIP obligations. So to summarize that, custody is about physical possession, control is about the right and responsibility to manage the record, and public bodies have to consider both aspects in order to fully comply with the FOIP Act. So if you do have any questions or you want me to pause so we can discuss anything further, I'm happy to do so. I have the chat open here on my side. So do throw in a comment if you want me to pause. Otherwise, I will just plow forward. Okay, so now we're going to talk about handling requests. So much of this information can be found in the FOIP regulations. I'm going to have a sip of my water. Okay, so handling requests specifies the processes that public bodies must follow when handling requests to access of information. So this includes timelines for responses or fee structures. To obtain access to a record, a person must make a request to the public body that the person believes has custody or control of that record. The request must be in writing, and it must provide enough detail to enable the public body to identify the record. And in a request, the applicant may ask for a copy of the record or to examine the record. So here is what you need to know about handling a FOIP request. So we have the duty to assist, a time limit for responding. There's required contents of a response. There's the mode that you're going to provide access, how access will be given. And then there is a way for processing complaints and reviewing your procedures, okay? So we will start with the duty to assist. Public bodies have a duty to make every reasonable effort to help applicants access records and understand the process of doing so. So this means that staff should guide applicants on how to make a request and clarify the scope of the request if needed to insist in locating the desired information. There's a time limit for responding. So the standard response time that a public body must respond to an access request within is 30 calendar days from the date the request is received. There can be extensions if the request is really complex and requires more time, or if it requires consultation with other parties, or if the volume of records involved is very large. But if an extension is needed, then the applicant must be informed of that decision and the new expected response time. You can't just leave them flapping in the wind. So the decision, so next there is the contents of the response. So the decision must clearly state whether the requested records are being granted or denied. So if access is denied, then the response must contain the reasons, including any specific exceptions or legal grounds under the FOIP Act, and a description a description of the records and an explanation of the applicant's right to request a review by the Information and Privacy Commissioner would be included if access is being denied. Then you have to determine how access is going to be given. This would be, probably covered in the request, how they want to receive it. So access can be provided in various formats, such as physical copies of documents, electronic files, or in-person viewing of records. If the applicant chooses to view the records in person, the public body must make arrangements for a convenient location and time. And the public body can charge fees for copying records, but they could also waive doing that under certain circumstances, like if the cost was minimal or if the applicant can't afford to pay. So a practical example of these 4 things in play would be a librarian helps a patron, we'll call him John, who is unfamiliar with the FOIP, the FOIP request process, by explaining how to fill out a request form and what types of information can be requested. John might submit the request on June 1st, and in that case, the library must respond by July 1st. So if they need more time, then they must inform John of the extension and the new deadline. So on July 1st, the library would respond, granting partial access, we'll say, to the records, and then explaining that some information is redacted due to privacy concerns. The response would include instructions on how John can appeal that decision. So John would choose, we'll say he chooses to receive electronic copies of the records. The library would email him the files and inform him of any applicable copying fees. And all of this ensures that transparency, accountability, and fairness in handling information requests is done underneath the FOIP Act. So we left out one important component. What if John is not content with the explanation of the redactions from the information that he's provided? So now we'll cover the complaint and review procedures. So these provide a mechanism for individuals to file a complaint regarding access to information or privacy breaches. And they detail the role of the Information and Privacy Commissioner in reviewing and resolving disputes. So this ensures that individuals have a clear and structured path to address any grievances related to access to information or privacy protection. And the process emphasizes mediation and informal resolution, but does provide for formal investigation and binding decisions by the Information and Privacy Commissioner if necessary. So there's also an option for judicial review to ensure fairness and compliance within the law. So here's how that works. So any individual who believes that their FOIP rights have been violated can file a complaint. This includes issues like denied access to records, improper handling of personal information, dissatisfaction with the response to a correction request. They can direct their complaints to the Office of the Information and Privacy Commissioner of Alberta, OIPC. And then complaints can be submitted in writing, detailing the nature of the issue and including any relevant documentation, such as the original request and the public body's response. So there are two components to the initial assessment. So there's the acknowledgement. The OIPC will acknowledge the receipt of the complaint and might request additional information. And then there's the assessment, where they assess whether the complaint falls within its jurisdiction and whether it merits a formal investigation. And then if so, there is the investigation process. So there are three components to investigation. There is the notification, where the OIPC will notify the public body involved that a complaint has been received, and it'll provide details of the complaint. And then it might request records and additional information from both the complainant and the public body to thoroughly investigate the matter. So that's information gathering. And then finally, they will do interviews and meetings. So they'll conduct interviews and meetings with relevant parties to gather further information and clarify the situation. So once they've done that, they're going to want to try mediation. So as I said a moment ago, they try to resolve things informally first, but there are mechanisms for formal investigation and processing if necessary. So mediation would be an attempt to resolve the complaint through an informal resolution, seeking a mutually agreeable solution without the need for formal investigation. So there's an element here of voluntary compliance. So public bodies may voluntarily comply with recommendations made during the mediation to resolve this issue. So if they don't, then there is the formal investigation and report. This all sounds very intense. So if mediation is unsuccessful, then the OIPC proceeds with a formal investigation. They prepare a detailed investigation report outlining their findings, conclusions, and recommendations and this report is shared with the complainant and the public body. And then they issue the compliance orders. So they issue orders requiring a public body to take specific actions, such as granting access to records or changing privacy practices. The Act establishes the Office of the Information and Privacy Commissioner to review and mediate any disputes regarding access to information and protection of privacy. But if that still fails, they can appeal it in court. So if either party is dissatisfied with the commissioner's decision, they can seek a judicial review by the Alberta Court of the Queen's Bench. So in this case, the court would review the decision and ensure that it was made fairly and in accordance with the law, and at which point they can uphold, modify, or overturn the commissioner's decision. So a person has options, so does a library. Okay, so now we are going to move on to part 2, unless anybody wants to pause at part 1. But there will be time for questions later, so it's okay, you don't have to rush. Okay, so part 2 is the protection of privacy. So the protection of privacy in the Act sets out rules for the collection, use, and disclosure of personal information by public bodies to protect individual privacy. So reviewing the definition of personal information, that is any recorded information that makes an individual identifiable. So their name, their birth date, their address, their phone number, their email, their age, their marital status, their financial information, health information, or educational history. Okay, so there are 5 elements to the protection of privacy. So there's the initial explanation to that, there's record management, there's security measures, there's the correction of personal information. Keeping things accurate is important for protecting privacy. And then there's also ongoing training and compliance. So we will dig right into that. Protection of privacy. So this section outlines the standards for the collection and disclosure and use of personal information by public bodies, which ensures compliance with privacy principles. So this is from the regulations. So when it comes to the collection of personal information, we have to consider purpose and necessity. Public bodies can only collect personal information if it is necessary for an operating program or activity. The purpose of collecting personal information must be clearly identified, and the collection must be relevant to that purpose. So then there's the methods of collecting information. Personal information can be collected directly from the individual and should be whenever possible. If information is collected indirectly, then the public body must have the authority to do so under FOIP. So an example of this might be a shared contract between a public library and a school division, where the parents have all signed a form for the children to automatically receive a library card to the public library. So they can only do that if they have the authority, and the authority to do so comes from the school division and the parents. Just a quick example there. Okay, so and then there's a notification. So individuals must be informed about the purpose of the collection and the legal authority for collecting the information, as well as the contact information for someone who can answer questions about the collection. And then finally, there is consent. Where applicable, individuals must provide informed consent for the collection of their personal information. Okay. Next, there's the use of personal information. So personal information can only be used for the purpose for which it was collected, or for a use that is consistent with that purpose. Consistent use is defined as a use that has a reasonable and direct connection to the original purpose. So accuracy is important here. Public bodies must make reasonable efforts to ensure that the personal information they use is accurate and complete. So this does not mean that you follow all your patrons on Facebook and you make note of, any deaths or any moves or, any status changes for them. They can come to you with updates, but reasonable efforts, like correcting things when they tell you it's wrong. And then there's access and correction, like what I just referred to. Individuals have the right to access their personal information and request corrections if they believe it is inaccurate or incomplete. And we will talk more about this in a minute. Next, there is the disclosure of personal information. So personal information can only be disclosed under specific circumstances, as outlined in the FOIP Act, which would include with the consent of the individual. It would include for the purpose for which the information was collected or a consistent purpose, when required by law to do so, to comply with a court order, for law enforcement purposes, again with appropriate documentation, or to prevent or address a threat to public health or safety. Third-party disclosures need to have particular care taken. So this means that when sharing patron data with a third party, they must ensure that the disclosure is authorized and also necessary. And they share only the minimum amount of personal information necessary to achieve the purpose. And then finally, when disclosing information to third parties, public bodies should use confidentiality agreements to ensure that the third party handles the information appropriately and is in compliance with FOIP. So a practical example of this, so for collection and use, the library uses member contact information to send reminders about due dates, notifications about reserved books, and information on library events, and then the library ensures that the contact information is up to date and accurate. For disclosure, the library discloses personal information, say, to a collection agency, only if a patron has significantly overdue materials and the library has exhausted other methods to recover the items. The library ensures that only the necessary information, for example, the patron's contact details and information about the overdue items themselves, is shared, and a confidentiality agreement is in place with the collection agency. This makes me think of the book cop from Seinfeld. I don't know if anybody remembers the episode where Jerry is dealing with somebody trying to hunt down overdue library materials, but it is a great episode. So you can be certain that the New York Public Library had a confidentiality agreement with that man's agency. So these rules ensure that personal information is collected, used, and disclosed in a way that respects individuals' privacy while allowing public bodies to perform their functions effectively, right? So nobody should be disempowered by FOIP. It's supposed to protect everybody in the relationship. Okay, next we have records management. It is no small thing. So records management is a crucial aspect of FOIP. It ensures that public bodies manage their records efficiently and transparently while protecting personal information. So this section establishes guidelines for the proper management, retention, and disposal of records to ensure accountability and transparency. So again, all of this how-to would come from the regulations. So we'll start with creation and capture. So creation and capture. So this refers to accuracy and completeness. Records must be created and captured accurately and completely to reflect the activities and decisions of the public body. A quick example of that would be when you are recording somebody's personal information when they sign up for a library card, you would be putting in their actual date of birth, not just the date that they came in, not a date of their choosing. You would be putting in information that's verifiable and accurate. And then there's standardization. Records should be created following standardized procedures to ensure consistency and reliability. Next, we have classification. This is this and this is not that, right? So organization, records must be organized in a systematic way that facilitates easy retrieval and management. Knowing that you filed something is not nearly as helpful as knowing where you filed something and being able to find it. Categorization. So this refers to records being categorized based on their function, subject matter, and sensitivity. Next, we have retention and disposal. So public bodies must follow retention schedules that specify how long different types of records should be kept. And records must be disposed of securely and in accordance with legal and regulatory requirements, ensuring that personal and sensitive information is permanently destroyed or anonymized. Next, we have access and retrieval. So records should be easily accessible to authorized personnel when needed for operational purposes or in response to access requests. And access controls must be in place to ensure that only authorized individuals can access sensitive or personal information. For example, if you've ever gone to an outreach event and used a paper form and then left all those forms in your car overnight or in your house on the kitchen table, that would have been very bad practice and a violation of FOIP. Once you have taken ownership of somebody's personal information, you have to go to great and reasonable lengths to ensure that it does not become compromised by external access. That's why we don't recommend using those forms. Okay, but I digress. So then there's security measures. Adequate safeguards must be in place to protect records from unauthorized access, alteration, or destruction. And then both physical and digital records must be protected using appropriate security measures, such as locked storage or encryption. And then finally, we have compliance and audit. So public bodies must adhere to records management policies and procedures that comply with the FOIP Act. And regular audits and reviews must be conducted to ensure compliance with records management practices and to identify areas for improvement. So putting this into library context, we'll look at the creation and capture of information. When a new library policy is developed, for example, the process is documented, which would include meeting minutes, draft versions, and final policy documents. So that is creating and capturing the process of what you did. Then there's classification. The records would be categorized by subject, for example, policies and procedures, and type, so draft or final version. Then there's retention and disposal. The retention schedule specifies that draft documents are kept for 1 year after the policy is finalized, while final versions are kept permanently. This is all just examples. And then there's access and retrieval. The final policy documents are stored in a secure, accessible location, and only authorized library staff can access them. Then there's protection and security. The documents are stored in a locked filing cabinet, for instance, for physical records, or an encrypted database for digital records. And finally, regarding compliance and audit, the library would conduct annual audits to ensure all records are managed according to the FOIP Act. Clear? All right. Okay. The correction of personal information is a very important component of FOIP, because individuals must have the right to request corrections to their personal information held by public bodies if they believe it to be inaccurate. For instance, the people who owned my house before me are struggling to change their address with the federal government, and as a result, I keep getting their very private mail. Luckily, I know who they are. It's very easy to hand it off to them, but it's really important that they're able to make those changes. And I personally question why it's so hard, but, you know, federal governments. Anyways, okay, so continuing. The right to request correction. Individuals can request the correction of their personal information held by a public body, and requests must be done in writing, and they must specify the corrections required. So the public body's duty is to make the requested correction if it agrees that the information is inaccurate, incomplete, or misleading. And if the public body does not agree to the correction, then it must annotate the record with the correction request so that it's on file that it was requested. Then there is the notification of correction or annotation. So the public body must notify the individual of the correction or annotation. The public body must also notify any other public bodies or third parties to whom the information was disclosed, if the correction or annotation might affect decisions made by those entities. So the book cop would have needed an update on Jerry Seinfeld's address if the library could have provided it. Then there is timeliness. Corrections should be made in a timely manner, and the public body should respond to the correction request within 30 calendar days. That still seems like an awful lot of time if you're just like, I want to update my address, but you know, you do things at the speed at which you can. So in a library scenario, Anna, a library patron, might notice that her mailing address in the library's records is incorrect. She recently moved and suspects that this might be why she isn't receiving notifications about her reserved books. I'm going to pause here to say that it is absolutely preposterous that she would be waiting for mail about books that are on hold, but whatever. Okay, so Anna decides to request a correction to her personal information. The steps that are taken. So she requests the correction. She visits the library and she fills out a correction request form, providing her new address and explaining that the old address is no longer valid. The library's FOIP coordinator might review Anna's request and verify her identity, or it might just be frontline staff, to ensure that the request is legitimate. Verifying her identity is super important, and this reminds me to circle back to why birth dates are important. I am one of 8 bazillion Jessica Morrises in the world, including at least 4 in the Lakeland. So if one of the other Jessica Morrises came in to update their address and they didn't verify which Jessica Morris it was, it would impact my personal information. So that's why that's an important component of the information that you take in when you register somebody. Anyways, and then the coordinator would agree that the information is incorrect and update Anna's address in the library's database. So the library would send a confirmation email to Anna informing her that the correction has been made. And since Anna's address was used to send overdue notices to a collection agency, because apparently she's a deviant, the library would also notify the book cops about the updated address to ensure that all records are consistent. Timeliness, the correction would be made within a few days, logically, and well within a 30-day response period, which is required by the FOIP Act. Does that make sense to everyone? Hopefully. Oh, well, like I said, time for questions at the end. Okay, so we are in our final section, which is training and compliance. So again, most of this information will be found in the regulations if you're wanting to fact check anything I say or refer to it later. Okay, so FOIP regulations mandate training for employees of public bodies to ensure they understand and comply with FOIP requirements. That's what we're doing here. So this is the regulations. Staff training. Staff need to be trained on records management practices, the importance of maintaining accurate records, and the requirements of the FOIP Act. ongoing awareness programs should be implemented to reinforce the importance of proper records management. Essentially, we should consistently reference FOIP in our day-to-day work. So training and examples. So there's the initial training, where new employees receive comprehensive training on FOIP principles, including the handling of access requests, privacy protection, and records management. For example, when a new staff member joins the library, they undergo an onboarding program that would include a module on FOIP. This module would cover the basics of handling personal information, the importance of privacy, and how to process access requests. And then there is ongoing training. So this would mean a regular refresher course and update to ensure that all staff are current on FOIP requirements, any changes in legislation, and aware of best practices. For instance, the library would schedule annual training sessions for all staff to review FOIP principles. They can just watch this video again and update them on any changes in the legislation. This would ensure that everyone is aware of their responsibilities. Then there's specialized training. So training for specific roles such as FOIP coordinator or record manager on the detailed application of the Act and regulations. The library's FOIP coordinator would attend advanced workshops on the latest FOIP developments and would share this knowledge back with the rest of staff. And then finally, there are training materials. So providing accessible resources such as manuals, online courses, workshops that staff can refer to as needed. The library would provide an online resource portal where staff can access FOIP manuals, guidelines, training videos, whenever necessary. Okay, and then finally, we have compliance. So we'll start with policies and procedures. Developing and maintaining clear policies and procedures for FOIP compliance, including how to handle access requests, protect personal information, and manage records. For example, the library should have detailed FOIP policies, including step-by-step procedures for processing access requests and guidelines to protect personal information. And then there's regular audits. So you would conduct regular audits and reviews of record management practices and FOIP compliance to identify or rectify any issues. The library might conduct quarterly audits of its record management practices. That sounds like a lot, maybe like annually, to ensure that they're in compliance with FOIP requirements. And any issues that are found would be promptly addressed. Then there's monitoring and reporting, establishing systems to monitor compliance with FOIP policies and report on any breaches or issues. This includes mechanisms for staff to report their concerns. So the library would use a tracking system to monitor the handling of personal information and compliance with FOIP policies, and staff would be able to report any potential breaches through a secure reporting mechanism. These are just examples. And then there's incident response. So something happens. Having a clear plan for responding to privacy breaches or non-compliance incidents, including notification, mitigation, and prevention strategies. So in a library context, in the event of a privacy breach, the library should have a response plan that includes notifying the individuals affected, investigating the breach, and implementing measures to prevent future occurrences. Thankfully, Northern Lights has not been one of the systems that has had to deal with a privacy breach, but they are a nightmare, a very expensive nightmare. And then finally, there is the documentation. Keeping thorough documentation of all FOIP-related activities, like training sessions, compliance checks, and responses to access requests is all part of maintaining good documentation. So for instance, the library should maintain comprehensive records of all FOIP-related activities, including staff training, logs, audit reports, and records of any access requests and their outcomes. Training and compliance are critical components of the FOIP Act to ensure that public bodies, including libraries, manage personal information responsibly and transparently. By providing thorough training and maintaining rigorous compliance practices, libraries can protect patron privacy and uphold their rights under the FOIP Act. And that brings us to the end.